Annyeonghaseyo. Welcome again to the Basic Philippine Law and Jurisprudence channel. Our topic for today is legal separation. The first thing that we have to consider in legal separation is that it does not annul or cut or dissolve the marital vinculum. Okay, the marital tie between the couple subsists. Okay, it is only a separation from bed and board, but it does not dissolve or annul the marital tie. Okay, the causes for legal separation are causes that exist after the celebration of the marriage. So unlike the grounds for making a marriage void from the beginning or from declaring the annulment of the marriage, okay, which is reflective of the absence of either the essential or the formal requisites or a defect in the essential requisites. The grounds for legal separation arose after the marriage, after the celebration of the marriage. So they are not reflective of either the absence or a defect in the requisites of marriage. Okay? And another thing that we have to consider with respect to legal separation is that the grounds for legal separation may also be considered or may also consist of manifestations of psychological incapacity under Article 36. However, the Article 36, as we have previously studied, okay, must in order to classify these manifestations, which are also grounds for legal separation, to be constitutive of psychological incapacity under Article 36. The grounds or the requisites laid down in the Tan Andal case must be established. Okay? Failure to establish the guidelines stated in Tan Andal would result in a finding by the court that the manifestation is not psychological incapacity under Article 36, but may be a ground for declaration of legal separation. Okay? So with that in mind, let us start discussing legal separation. Article 55 enumerates the grounds for legal separation as follows. Repeated physical violence. So we must underscore the word repeated. So if it is only a single instance of physical violence, the same cannot constitute a ground for legal separation. There must be a repetition. And there is it may be for any cause. The reason for the infliction of physical violence may be for any other cause. Okay? Grossly abusive conduct directed against the petitioner, a common child or a child of the petitioner. So the physical violence may be directed against the spouse, a common child of the couple, or a child of only one of them. Okay? And the grossly abusive conduct need not only refer to physical violence. It may be a conduct that is grossly abusive, such as words, for example, abusive words, emotional or psychological abuse. Okay? Number 2, physical violence or moral pressure to compel the petitioner to change religious or political affiliation. So in this case, a single instance under ground number 2, a single instance of physical violence is sufficient, provided that the reason for the infliction of physical violence is to compel the petitioner to change religious or political affiliation. Okay? So, the third ground, attempt of the respondent to corrupt or to induce the petitioner, a common child, or a child of the petitioner to engage in prostitution or connivance in such corruption or inducement. So a mere attempt in this case would be sufficient. It is not necessary that the petitioner or the common child or the child of the petitioner engages in prostitution. Okay? It is sufficient that he merely attempted to corrupt or to induce these people to engage in prostitution, or he connived with another person in order to corrupt or to induce this person. Okay? Fourth ground, final judgment sentencing the respondent to imprisonment of more than 6 years even if pardoned. Okay, so the main requirement here is a final judgment of more than 6 year imprisonment. The offense committed is immaterial. What is important is that the penalty imposed by the final judgment is more than 6 years in prison. Okay? Fifth ground, drug addiction or habitual alcoholism of the respondent. Okay? This is also one of the manifestations. This can be one of the manifestations of psychological incapacity, just like in Tanandal. Tanandal, drug addiction, the respondent was hooked on drugs. Okay? Sixth ground, lesbianism or homosexuality of the respondent. Okay, remember, to be a ground for avoidable marriage, okay, homosexuality must be exist at the time of the marriage. Diba? Concealment. It is the concealment of the homosexuality that is considered as a fraud. Okay? That is enough to make the marriage voidable. But if the lesbianism or homosexuality was not established to be existing at the time of the marriage, but the onset thereof existed after the marriage, it can be a ground for legal separation. Okay? 7, contracting by the respondent of a subsequent bigamous marriage, whether in the Philippines or abroad. So, if you're, for example, if you are the wife in the first marriage, and your marriage is valid, it has all the essential and formal requisites under the law, okay? But then, your relationship with your husband turned sour, okay? And then your husband contracted another marriage. Obviously, the second marriage is a bigamous marriage. Now, what is your recourse? Okay, one of the recourse available to the wife or to the spouse of the first marriage is to file a petition for legal separation. If your first marriage does not suffer from any defect, okay, or it does not suffer from any of the absence of the requisites. Okay. Eighth ground, sexual infidelity or perversion. Okay, this could also be a manifestation of psychological incapacity. Ninth ground, attempt by the respondent against the life of petition. Okay, a mere attempt, just like in corruption or inducement to prostitution, a mere attempt at the life of the petitioner would be sufficient to constitute a ground for the filing of legal separation. What about an attempt on the common child or a child of the petitioner, the rules, the family code did not provide the same as one of the grounds for filing a legal separation case. So what is not included is excluded. And 10th ground, abandonment of the petitioner by the respondent without justifiable cause for more than 1 year. So what is important on the last ground is the period or of abandonment. It must be for more than a year. And the second important requirement is that it must be without a justifiable cause. If there is a justifiable cause for the abandonment, like for example, if one of the couple went abroad to earn a living, worked abroad to earn a living, then there is justifiable cause. Or if one of the couple left the other because he was always physically beaten by the other spouse, then that is justifiable cause also. And that would not give the person who was allegedly abandoned a cause for the filing of a petition for legal separation. Okay, legal separation as distinguished from psychological incapacity. If the psychological incapacity is proved, the marital bond is cut and the parties can remarry. In legal separation, it is merely separation from bed and board. Number two, the grounds for legal separation, such as physical violence, sexual infidelity, abandonment, drug addiction, may also be considered as manifestation of psychological incapacity. And third, if the totality of evidence in a nullity based on psychological incapacity failed to prove the gravity, antecedents, and incurability of the ground relied upon, legal separation is the appropriate action. Okay. We now go to the first case, Nahera versus Nahera. Okay. In filing a petition for psychological incapacity, you can include in your prayer an alternative prayer for legal separation. Why? Because if the court finds that you were not able to prove the gravity, antecedents, and incurability of the psychological incapacity, at least the court can declare that a legal separation is proper. Okay, so although the marital vinculum is not severed, at least the spouses can be separated from bed and board. Okay. So in this case, in the case of Nahera, the manifestations are as follows. The failure of the husband to give financial support while he was working as a seaman. Okay? He is a habitual drunkard. He is hooked in marijuana. He inflicted physical injuries on the wife. And he attempted to kill her with a bolo. And he abandoned the petitioner and never returned. So if you will notice, all of the manifestations of psychological incapacity, okay, are also considered as grounds for legal separation. So the trial court decreed only a legal separation. In other words, the alternative prayer was granted, but the petition for nullity based on psychological incapacity was denied. It was upheld by the Supreme Court. The Supreme Court said physical violence or grossly abusive conduct of respondent toward petitioner and respondent's abandonment of petitioner without justifiable cause for more than 1 year are grounds for legal separation only and not for annulment of marriage. So the alternative prayer for legal separation was granted. Okay, in Laurena versus Court of appeals. Again, this is a case filed to declare the nullity of the marriage based on psychological incapacity. Now, what are the manifestations of the incapacity? Okay. First, the respondent gave priority to the needs of his parents rather than his family. He would come home always past midnight. He even tried to convert her to his religion. And then also, respondent was a womanizer and he abandoned their conjugal home and stopped supporting their children. The trial court found that the manifestations of respondents' incapacity were not so serious as to consider him psychologically incapacitated. Remember the gravity. So if the manifestations were not that serious, the court could deny the petition but say that legal separation would be appropriate. However, sexual infidelity, repeated physical violence, homosexuality, physical violence, or moral pressure to compel petitioner to change religious affiliation and abandonment are grounds for legal separation but not for declaring a marriage void. In sum, the totality of the evidence presented by the petitioner failed to show that respondent was psychologically incapacitated and that such incapacity was grave, incurable, and existing at the time of the solemnization of the marriage. Okay? Next case is Navales versus Navales. So again, this is a case to declare a marriage null and void pursuant to psychological incapacity. However, the trial court found that the totality of evidence presented by the petitioner is insufficient to sustain a finding that Nilda is psychologically incapacitated. According to the petitioner, the manifestations were the wife was a flirt before the marriage, which flirtatiousness recurred when he started working as an aerobics instructress. So he saw Nilda being kissed by another man. However, these acts are insufficient to establish a psychological or mental defect that is serious, incurable, or grave. So the gravity and the seriousness based on the manifestations of flirtatiousness and seeing him being kissed by another man, they are not so grave and serious as to constitute psychological incapacity. Article 36 contemplates downright incapacity or inability to take cognizance of and to assume marital obligations, irreconcilable differences, sexual infidelity or perversion, emotional immaturity, and irresponsibility do not by themselves warrant a finding of psychological incapacity. Also, the Supreme Court observed in this case that there was an admission of good and harmonious relationship during the early part of the marriage. That fact weakened the assertion of psychological defect existing at the time of the celebration of the marriage, which deprived the party of the ability to assume the essential duties of marriage and its responsibilities. Having failed to demonstrate that there was a natal or supervening disabling factor or an adverse integral element in Nilda's character that effectively incapacitated her from accepting and thus complying with the essential marital obligations, and that her psychological malady existed even before the marriage, hence the court cannot give way to the said assessment. Okay, we have the case of Paras versus Paras. Okay, in this case, petitioner Rosa married Justo. They had children, and then 29 years after, Rosa filed a complaint for annulment of her marriage. According to Rosa, the manifestations are as follows. Her business assets, the respondent dissipated her business assets, forged her signature in one mortgage transaction. He lived with a concubine and started a child with her. He did not give financial support to his children. Okay? However, the trial court denied the petition. Why? Because Rosa's grounds, such as infidelity, profligacy, falsification of signature, failure to support the children, and abandonment. While this court is convinced that the charges hurled against Justo by Rosa, such as sexual infidelity, falsification, abandonment, and inadequate support, are true, there is nothing in the record showing that they were caused by a psychological disorder. In other words, the totality of the evidence is not sufficient to show that Justo is psychologically incapacitated to comply with essential marital obligations. So the records indicate that the marriage between the parties had a good start, resulting in the birth of their 4 children. So the early days of their cohabitation were blissful. However, the passage of time appeared to have taken its toll on their relationship. Justo appeared to have been the result of irreconcilable differences caused by the death of their 2 children and financial difficulties due to his failure to win the mayoralty election and to sustain his law practice. There is no evidence that Justo's defects were present at the inception of the marriage. His defects surfaced only in the latter years when these events took place. So in a declaration of nullity of marriage cases under Article 36, if you allege that the relationship between the parties were blissful from the beginning, this is already an indication that there was no juridical antecedent of the psychological, of the alleged psychological incapacity. Why? Because it could be through the passage of time, the couple got tired of each other. So it is not the psychological incapacity that is contemplated. So the manifestation may be a ground for the declaration of legal separation, but not the nullification of the marriage on the ground of psychological incapacity. So what is clear in the case of Paras is a husband who has gone astray from the path of marriage because of a conflicting relationship with his wife and her family and repeated life setbacks. While these do not justify his sins, they are not sufficient to establish that he is psychological incapacitated. Article 36 should not be equated with legal separation, in which the grounds need not be rooted in psychological incapacity, but on physical violence, moral pressure, moral corruption, civil interdiction, drug addiction, sexual infidelity, and abandonment. At best, the evidence presented by the petitioner refers only to grounds for legal separation. We have the case of Ong versus Ong. So, in this case, this is a complaint for legal separation, alleging that her life with William was marked by physical violence, threats, intimidation, and grossly abusive conduct. Okay? The RTC granted the legal separation. However, the Supreme Court denied the petition. Okay. In denying the petition, the Supreme Court said, also without merit is the argument of William that since Lucita has abandoned the family, a decree of legal separation should not be granted. Legal separation shall be denied when both parties have given ground for legal separation. The abandonment referred to by the family code is an abandonment without justifiable cause for more than 1 year. Since it is established that Lucita left William due to his abusive conduct, such does not constitute abandonment. As Lucita has adequately proven the presence of a ground for legal separation, the court has no reason but to affirm the findings of the RTC and the C. So, what is important in the case of Ong versus Ong is the uh, explanation or clarification on what constitutes abandonment. That could be a ground for legal separation. The abandonment must be without a justifiable cause. So if the spouse abandoned the other spouse because of repeated physical abuse or physical abuse, the said abandonment could never fall as a ground for legal separation. So only one of the parties have given cause for legal separation. Because if both parties have given cause for legal separation, that is a ground for the denial of the petition. So in this case, only the husband have given cause for legal separation. The abandonment of the wife could not have made her also an offender. Why? Because the abandonment was with justifiable cause. Okay. Now, when should legal separation be denied? Okay. Article 56 tells us the grounds for the denial of cases for legal separation. When the aggrieved party has condoned the offense or act complained of. So if the ground for legal separation has been condoned by the offended party, then the legal separation may be denied, where the aggrieved party has consented to the commission of the offense or act complained of. Third, when there is connivance between the parties in the commission of the offense or act constituting the ground for legal separation. Fourth, where both parties have given ground for legal separation. Fifth, when there is collusion between the parties to obtain the decree of legal separation. And last ground, when the action is barred by prescription. Okay, so that brings us to the next article, which provides for the prescriptive period for filing a case for legal separation. An action for legal separation shall be filed within 5 years from the time of the occurrence of the cause. So just like fraud, making the marriage voidable, must be filed within 5 years from the occurrence of the cause. Okay? There is also a cooling off period if you file a case for legal separation. It will not be tried before 6 months has elapsed since the filing of the petition. Why? In order to give the parties the opportunity to reconcile. Okay? So the action or the trial will not start until 6 months have elapsed from the time of filing. We have the case of Usuego versus OMB. Rosa filed a complaint for concubinage against Alfredo. Okay? Why? Because Rosa found out about Alfredo's extramarital relationship. Okay, so the ombudsman ordered the filing of the information for concubinage. However, Alfredo argued that Rosa has already pardoned his concubinage because she has admitted to know is womanizing, and yet she continued with with their relationship, as demonstrated by Rosa's annual visits to him in Davao City. So Alfredo was contending that Rosa has already condoned the offense. So the petition for the legal separation should be denied. In Busuego, the Supreme Court defined what is meant by condonation. It is the forgiveness of a marital offense constituting a ground for legal separation. Condonation is the conditional forgiveness or remission by a husband or a wife of a matrimonial offense which the latter has committed. Condonation is implied from sexual intercourse after knowledge of the other's infidelity. Such acts necessarily imply forgiveness. It is entirely consonant with reason that if the wife freely consents to sexual intercourse after she has full knowledge of the husband's guilt, her consent should operate as a pardon of his wrong. A condonation is the forgiveness of a marital offense, constituting a ground for divorce and bars the right to divorce. But it is on the condition implied by law, when not expressed, that the wrongdoer shall not again commit the offense, and also that he will treat the other spouse with conjugal kindness. So a breach of the condition will revive the original offense as a ground for divorce. Condonation may be expressed or implied. So a single voluntary act of sexual intercourse by the innocent spouse after discovery of the offense is ordinarily sufficient to constitute condonation, especially against the husband. Okay. So the only general rule in American jurisprudence is that any cohabitation with a guilty party after the commission of the offense and with the knowledge or belief on the part of the injured party will amount to conclusive evidence of condonation. But this presumption may be rebutted by evidence. So, is the annual visit of the wife to the husband in Davao City sufficient to be construed as a condonation, and therefore the legal petition for legal separation must be denied? Their continued cohabitation as husband and wife, construed from Rosa's annual visits to Davao, is not acquiescence to Alfredo's relations with his concubines. It is true that the offended party has been patient with her husband's shortcomings, but that seems to have been due to his promises of improvement. Nowhere does it appear that she has consented to her husband's immorality or that she has acquiesced in his relations with his concubine. We have the case of Castro versus Court of Appeals. In this case, although legally married to the complainant, he was separated from him, and their marriage had not been dissolved. Appellant cohabited and had sexual intercourse with his co-defendant, who lived with him in his house, which used to be his and the complainant's matrimonial domicile. Okay, so complainant's letters in which she referred to Lolita as appellant's querida or mistress, and the fact that she even filed a civil action against her husband for legal separation based on illicit relationship leaves no room for doubt that she had never consented, pardoned, or condoned the same. Okay, Matubis versus Praxedes. Okay, the ground for legal separation in Matubis is abandonment and concubinage. Okay, using this ground, Socorro filed a complaint for legal separation against Soylo. Okay. For failure to agree on how they should live as husband and wife, the couple agreed to live separately from one another, and that both of them is free to get any mate and live with as husband and wife without any interference, nor either of us can prosecute the other for adultery or concubinage or any other crime or suit arising from our separation. So in other words, they executed an agreement, okay, that they could live with any other person and that they would not file any adultery or concubinage case. Okay. So the defendant began cohabiting with Asuncion, and Asuncion gave birth to a child. Okay. So the legal separation case was dismissed. Why? Because legal separation may be claimed only by the innocent spouse, provided there has been no condonation or consent. The plaintiff has consented to the commission of concubinage by her husband. This stipulation is an unbridled license she gave to commit concubinage. Having consented to the concubinage, the plaintiff cannot claim legal separation. Having condoned or consented in writing, the plaintiff is now undeserving of court's sympathy. Just like in the cases of declaration nullity as well as annulment of marriages under Articles 35, 36, 37, 38, 45, 46. Okay? It is required that parties to legal separation, okay, must have appeared before the fiscal. Okay, and the fiscal would conduct an investigation on whether or not there was collusion between the parties. Why? Because a case for legal separation, just like a case for nullity and annulment of marriages, cannot be had ex parte. Meaning, there must always be the fiscal who should represent the state. Okay. No legal separation may be decreed unless the court has taken steps towards the reconciliation of the spouses and it is fully satisfied that despite the said efforts, reconciliation is highly improbable. Okay? No decree of legal separation shall be based on stipulation of facts or confession of judgment. Okay, so it is the role of the fiscal to determine if there is really no possibility of reconciliation. After the filing of the petition for legal separation, the spouses shall be entitled to live separately from each other. That is actually the effect of legal separation. The marital obligation to live together will be dissolved, meaning they're entitled to live separate from each other. Okay, during the pendency of the action for legal separation, the support of the spouses, support of the common children shall be governed by Article 14. Okay. What is the effect of legal separation? Under Article 63, again, the spouses shall be entitled to live separately, but the marriage bond shall not be severed. So you are still considered as legal spouses. In the eyes of the law, you are still married to each other. But the obligation to live together is nullified. Okay? Second, the absolute community or the conjugal partnership shall be dissolved and liquidated, but the offending spouse shall have no right to any share of the net profits earned by the absolute community or the conjugal partnership. So there will be a liquidation of the property regime. Okay? But with respect to the net profits, the offending spouse will not be entitled to it. The custody of the minor children shall be awarded to the innocent spouse. Fourth, the offending spouse shall be disqualified from inheriting from the innocent spouse by intestate succession. Remember, intestate succession, meaning that if the injured spouse sees it fit to give the offending spouse uh, inheritance by will, he can do so. Okay. However, provisions in favor of the offending spouse made in the will shall be revoked by operation. But if it was made after the decree of legal separation, then it can be considered as valid. But if it was made before the decree of legal separation, it will be revoked by operation of law. Article 64, after the finality of the decree of legal separation, the innocent spouse may revoke the donations made by him in favor of the offending spouse, as well as the designation of the latter as beneficiary in any insurance policy, even if such designation is stipulated as irrevocable. The revocation of the donation shall be recorded in the registry of property. So the innocent spouse has the option whether to retain the offending husband as a beneficiary in an insurance policy or to be the beneficiary of any donation. Okay, after the finality of the decree of legal separation. If he does not do anything to revoke the same, then it means that the donation as well as the designation shall remain valid. The action to revoke the donation must be brought within 5 years from the time the decree of legal separation has become final. So, what is the effect again of legal separation? The marital vinculum subsists. That is the reason why neither party can have a paramour. Why? You can be prosecuted for bigamy or you can be prosecuted for adultery or concubinage. The parties cannot insist on sexual intercourse with each other. The wife can continue using her maiden name. The parties are relieved of the obligation to live together. The custody of the minor children is given to the innocent spouse. The guilty spouse cannot inherit from the innocent spouse, whether by testate or intestate succession. The absolute community shall automatically be dissolved and liquidated. Donations made by the innocent spouse to the guilty spouse may be revoked, and designation of the guilty spouse as beneficiary may be revoked even if the same is irrevocable. Okay, now, what if there is already a decree of legal separation? And then after a few years, the parties reconciled and decided to live together again. What is the remedy that is available to the parties? Will they be required to file a petition to revoke the previous decree of legal separation? The answer is no. What is only needed is to file a joint manifestation under oath, okay, that they have already reconciled. Okay. What is the effect of reconciliation? So the legal separation proceedings, if pending, will be terminated. Okay, if there is already a final decree, it will be set aside. But the separation of property and any forfeiture of the share of the guilty spouse will subsist unless the spouses agree to revive their previous property regime. Okay, the agreement to revive the former property regime shall be executed under oath and shall specify the properties to be contributed anew to the restored regime, those to be retained as separate properties, and the names of all their known creditors, addresses, and amounts owing to each. The agreement of revival and the motion for its approval shall be filed with the court in the case where the legal separation proceeding was held. Okay, so All that is needed is to file a joint manifestation under oath that you have already reconciled. Okay, so that's it for today. Thank you for listening.